right, go ahead.
Mics are on. Ready?
Yeah, whenever you are.
All right. Let's please, we'll call the meeting to order. Would you call the roll?
Keith Campbell,
Here.
James Steele Smith, it's not here. Steve Eisenbrown,
Here.
Bill Gallagher,
Here.
Kyle Ferris,
Here.
Chris Baroni, not here, and Amy Richardson. Here.
Ready? We need a motion to approve the agenda with flexibility.
I'll make a motion, we accept the agenda with flexibility.
The second,
I'll second that.
all in favor, say aye.
Aye.
Opposed, same sign. The agenda's approved. This time we'll table the minutes till after. We got 4 minutes anyways. Everybody read the minutes or not, or any correction? Not, we can.
Make a motion.
Did you read it?
Yeah, right.
I read it.
Anybody have any corrections or additions to the minutes?
I have none.
Hearing none, then we'll take a motion to approve the minutes as presented.
I make a motion, we accept the minutes as presented.
You have a second?
I second it.
Motion, approve the minutes as presented in a second. All in favor, say aye.
Aye.
Aye. Those same sign, the minutes are approved. Down the agenda here. We had no new applications tonight. I don't believe. I haven't seen them on here. Anyone here have an application? Okay. Zoning director's report. Oh, he's on vacation. Reminder, our next meeting date's January 20th. And that will also be an organizational meeting. So before we leave, we'll have to set the time for the organizational meeting. Guess we can do that right now. We said that 2 minutes before the hearing. So You want to do the organizational meeting at 7:30 or 7 o'clock?
I'm good with 7.
7 works for me.
7 works.
7 for you, okay? Organizational meeting for 7 o'clock with the regular meeting at 7:30.
Gotcha. I just sent about 3 of them today.
Okay, it's 7:35. And we need a motion to recess the regular business meeting till after the hearing.
I make a motion to recess the regular meeting until after the hearing.
Second,
I second the motion.
all in favor, say aye.
Aye.
Opposed, same sign. Okay, that part for recess. We'll call the hearing to order. Secretary, you call the roll, please.
Keith Campbell,
Here.
Jim Steele Smith, Steve Eisenbrow,
Here.
Bill Gallagher,
Here.
Kyle Ferris.
Here.
Chris Baroni. Amy Richardson.
Here.
Okay. I'll explain the procedures of the hearing for everybody right now. First off, we normally have a staff report by the zoning director, but he's on vacation, so that will be skipped today. We'll hear from the applicant or their representative. Jimmy will hear from any adjoining property owners, and then any general public. All comments must be relevant to the issue before the board. All may be cross-examined on their statements. All questions of presenters and cross-examination will be directed to the chair. All persons wishing to speak will come up to the podium. All persons that are speaking will state their name and address for the record. All persons speaking and giving testimony will be sworn in. So all those who wish to speak tonight, you stand right now and be sworn in, please. If you're going to speak, you need to stand. Yes. Do you swear to tell the truth? Say, I do.
Yes.
Okay, thank you. This time, are there any questions on the procedures? Before we proceed, are any abstentions for any board members? Madam Secretary, was this advertised in the paper record? Did you read that ad? Read the record.
Public notice, the Harlem Township Board of Zoning Appeals is being asked to consider the following. Barry and Rachel Jacobus are seeking a variance to reduce the road frontage on their property at 3363 Green Cook Road, Johnstown, Ohio 43031. Parcel number 31641001037000. The hearing is scheduled for December 16th. 2024 at 7:35 PM at the Harlem Township Building. 3883 South State Route 605, Galena, Ohio, 43021. To view the application and accompanying documents, please call 740-965-2661, extension 2, Monday through Friday, 8 to 12 p.m. To schedule an appointment to view on our website at www.harlemtwp.com. This hearing is open to the public. The hearing is also available on Zoom. Keith Campbell, Chair.
Thank you. At the time we received the application last month, the list of joint property owners was reviewed and found to be complete. Madam Secretary, were the joint property owners notified by first-class mail?
Yes,
Did you have any return?
I did not.
Well, at this time, if the applicant could come up to the podium, state your name and address, and give a brief summary what your request is.
My name is Jared Jacobus. My address is 3363 Green Cook Road, Johnstown, Ohio, 43031. We are requesting a variance for the road frontage to allow for a lot split of our property.
Okay. This time, we have any adjoining property owners here who wish to speak? Do come to the podium, state your name, address.
Good evening. My name is Brian Hunt. I'm an attorney, legal counsel for Edward Coppola and Barbara Coppola, who are adjacent property owners. I've got a few comments, but before I get started, I would like to verify. I sent in a memorandum last week to Michael Cannon and Corey Go. Was that forwarded to this board for review?
Mike has been on vacation, so.
So you have not seen the memorandum that was filed? Okay.
No.
I would like to submit that now into the record. Submit two things. I'll label Exhibit A. The email that submitted the memorandum to Mike on Friday and Corey Go.
Thank you.
Exhibit B is a copy of the memorandum. May I approach?
Thank you. Much.
Thank you.
I had prepared some comments under the assumption that you had seen this and read it, so I will try to elaborate a little bit more.
Why don't you just let us read it?
Okay. You want to take some time to read it?
We'll take a about 5-minute recess here and give us all a chance to look at this over. Been noted. Anyone have any questions or?
You have a question? Should we go back and let him? I have a question, a procedural question. Yeah. So was there a copy of the memorandum provided to the applicants? And if not, do they need time to review the memorandum so they can properly prepare to reply to it?
I can answer that. A copy was not provided to the applicant. And I'd say it'd be no different than any other public comment that's submitted in writing. I don't know if that's ever forwarded to the applicants or not.
I think what we should do, though, is we go on with some of the information that we have. And from there, we'll make a decision if maybe they should have time to digest that. And see what their comments will be and then bring it back, later on. Some of the things that I have discovered, I need to, bring up too also. But at this point, we'll say, so noted, we have your information here.
Okay.
Take that into consideration also, but we have some other stuff we will consider also.
Okay. I think just to highlight a couple of points from the memorandum, I won't, of course, go back over all of it. We view the application as facially deficient. It fails to clearly set forth what parts of the resolution they're seeking a variance from. They also mentioned a lot split, but a copy of the lot split was not completed and part of the application packet for this particular variance. And I don't think it's been introduced in the record in these proceedings. As it relates to the variance themselves, a couple of things that are important. People aren't entitled to a variance simply because they want one. They have to be able to show that there's practical difficulties, and that's what the court in Duncan said. And practical difficulties exist whenever an area zoning requirement unreasonably deprives a landowner of a permitted use of property. There's been no evidence submitted to that effect. The property itself should not qualify for a variance. We're dealing with a roughly 5.49 acre parcel, rectangular in shape, that measures roughly 240 feet by 980 feet. There's no exceptional narrowness, shallowness, or unusual shape at issue here, nor are there any exceptional topographic conditions or other extraordinary conditions regarding the property that are creating practical difficulties. The property is being used in the same manner that it's always been used, which is a single family residence. And it's difficult to conceive how a property of this size and shape, which has existed for so long without a variance ever being needed before, is subject to unreasonable zoning regulations. The application itself states that the property owner is simply seeking a variance in order to split the property into two parcels, presumably to derive an economic benefit. Ohio law is clear, however, that it is not this board's duty to ensure that the applicants have the best use or even a particularly optimal use of the property. And an economic benefit on its own is not a sufficient basis to justify granting a variance. I would also direct this board to section 28.06 of its zoning resolution. Sections B and C are important. B is the hearing and decision. It says at such hearing, like we're having this evening, it says the applicant shall present a statement and adequate evidence in such form as the Township Board of Zoning Appeals may require. The burden of proof will be the responsibility of the applicant. So in other words, it's not my client's responsibility to try to persuade you that practical difficulties don't exist. It's the applicant's responsibility to prove that they do. There are also several criteria that are listed in subsection C. They are: number one, that the variance is not contrary to the public interest. Number two, that it is justified due to special conditions. Number three, that it is justified because the literal enforcement of the resolution would result in unnecessary hardship. And then number four is broken into 7 subparts, which are those 7 Duncan factors that are listed in the memorandum. Again, the applicant spoke this evening and did not provide any evidence at all on any of those points. And I don't believe there's anything in the application that speaks to any of those either. So I would respectfully urge the board that it cannot approve this application this evening because the burden of proof, which the applicant is required to bear, has not been met. No evidence has been supported to show that practical difficulties exist and thus the variances are not necessary.
All right, thank you.
Would my clients like to speak as well?
Pardon? You want to say something?
Yeah.
Okay. Give your name and address for the record, please.
My name is Edward Capalla. And my wife Barbara and I own the property at 3425 Green Cook Road, Johnstown, which is contiguous and directly south of the Jacobus property that is requesting the lot frontage variance. We're opposing the granting of the requested variance for the Jacobus. My discussion will just talk a little bit about the history of the establishment of the neighborhood, which you have a enclosure in Mr. Hunt's packet. We purchased our vacant property in 1973 from Gatchel Realtors, who was a broker and a house builder, and began building our forever dream house in 1976. And have lived there ever since. Our property is one of 13 lots of 5.5 acres that Mr. Dave Gatchel and Mr. William Smith. Mr. Smith owned the 70+ acres that were divided into 13 lots of approximately 5.5 acres. You have a copy of the plotted lot plan area in the memorandum sent to you by our attorney, Mr. Hunt. The area was developed to establish 5+ acre country-sized contiguous lots for families wanting to experience country living without the threat of their neighbor's property being subdivided in the future with multiple dwellings. This was both Mr. Gatchel and Mr. Smith's vision and marketing strategy, and was the expectation of those that purchased one of the 12 lots and built their house. At least that was our expectation when we purchased our property. The lot owned by Jacobus already had a house on it that was built in 1961 and remains as such. The vision of Mr. Gatchel and Mr. Smith, all who purchased one of the lots, has stood the test of time for 50 years. The lots have not been split. None of the 13 lots plotted over 15 years ago were ever subdivided until the lots split on Mr. Witter's property, which is contiguous and adjacent on our south side. So we have a flag lot on our south side already. That was done in 1922. The 13 lots plotted in 1972 and the resulting homes built established a country neighborhood surrounded by open farmlands. Our feeling is taking a dedicated neighborhood established over 50 years ago with known tract sizes and subdividing them now for potential financial gain is not in the spirit of the original intent of these lots. Like us, some of the current owners are original purchasers. We understand that flag lots less than 5 acres are appearing in Harlem Township due to the growth of Delaware County and Harlem Township, and originate from large open tracts of farmland. However, the folks that buy these flag lots go into it with eyes wide open. They know what they're getting. Taking a dedicated neighborhood established over 50 years ago and subdividing them now with lot splits for financial gain is not in the spirit of the original intent of these 13 properties.
All right, thank you. Anyone else have anything to bring up?
My name is Barbara Capalla, and my husband and I are to live at 3425 Green Cook Road, the property that is adjacent to the south of the Jacobus property. I would like my comments to be a matter of record and ask that you hold any questions until I finish my opposition comments. I would like to share with you the personal impact that approving the Jacobus variance proposal will have on the Capalas. First, the flag lot split would have around a 700-foot of excessive driveway traffic and noise close to our current house and patio. Our experience with the Witter flag lot, this is the flag lot on the other side of our property. Our experience with the Witter flag lot construction has constantly yielded over 50 gravel dump trucks, many cement trucks, septic tanks, soil trucks, etc., and unmarked worker vans bringing groups of workers on the weekends, evenings, and holidays. We have had to build a 200-foot of solid buffer fencing, which is spending considerable amount of money to block the view and the sounds of the Witter driveway. The traffic will continue after the construction. Secondly, we would have the loss of privacy on the north side of our house with the proposed Jacobus lot split. A similar problem with the Witter flag lot required us to build an accessory outbuilding to block their completely open view into our backyard and the entire back of our house. Additional landscaping would also be required. Thirdly, the constant stress about the financial, environmental, and emotional uncertainty for the Capalas that will result from the spot zoning of the Jacobus property that would allow new conditional uses of the property under the potential FR1 rezoning that are not currently allowed under their present AR1 zoning. This would even happen without a lot split. Fourth, the unattractive, claustrophobic, non-rural view of our property, unlawfully sandwiched between two flag lots, would look like a bowling alley with two gutter ball returns on both sides. This would definitely negatively impact the resale value of our property. In fact, I would not purchase this property under these conditions. Would you? Thank you for your attention.
Thank you. You have any rebuttals you wanted to answer to, or?
So this hearing is for Jared Jacobus, 3363 Green Cook Road, Johnstown, Ohio, 43031. So this hearing is for variance to rezone the property. So use of the property isn't really taken into consideration, like future use of the property isn't taken into consideration for this meeting. This meeting is for simply rezoning the property from FR1 to AR1 that could allow for a lot split. The main reason is not monetary. The main reason is to turn a non-conforming property into two conforming properties, which would be in the best interest of the township. The idea that the zoning has progressed where properties aren't conforming to the standards to be able to turn two properties into conforming lots would be the best interest for all members of the community. Also, there's no like statistical evidence that building homes on the reasonably substantial size properties of more value than homes surrounding will lower property values. That tends to increase property values for neighbors. Currently, with the construction of all the corporations coming in the surrounding areas, this area cannot handle the inflow of personnel that's needed to run those operations combined with all the other ancillary businesses that will no doubtly take place. And in the near future, there'll have to be smaller allotted homes. There'll have to be multifamily homes to support all of the people that are coming into this town to support those businesses. And I don't think that this would have any kind of negative impact on the residents. Of course, they appreciate when the property was turned from farmland into smaller lots to put houses. I don't think they would have been opposed to that since they benefited from that. And I don't think that claiming that the intent of the neighborhood is to remain the same forever. Obviously, the original intent was farmland, so it changed in time. And now there are future changes coming to this neighborhood and the surrounding area. Thank you.
Anyone else have any comments or questions? Okay, with this time, we'll take a break from any public comments. I want to read some of the research that I did on this property. So here's some of what was mentioned is that this Mr. William Smith did originally own the farm acreage there. Going back to the records of transferring of ownerships and deeds and what transpired, Robert and Izetta Whipple purchased Mr. Smith, and that was in September 16th of 1972.
That's reversed. Mr. Smith purchased it from Mr. Whipple.
Okay, right. Just read my.
I don't want to interrupt.
That's a fine, okay.
Or something.
Anyways, that was when the 13 lots were made in September 16th of 1972. That time, there was no zoning in the township, or it was like zoning was county-wide, was no individual township zoning. So that frontage at 200 and whatever, 50 something feet or whatever it is, I forget now, was what those 13 lots were split to. So that when Harlem Township zoning was established in 1978, 1988, excuse me. That's when the frontage was changed to 300 feet. So these lots had been established for a long time. And when the zoning was established, it made 13 lots non-conforming. Had not come up until recently that anyone would want to split one of the lots. Our resolution allows you to split an AR1 lot that's over 5 acres into two point whatever acres lots you want. They have to leave over 2 acres. And then the frontage it gets reduced. But like I say, these lots were generated before the zoning came in. So the zoning made the hardship splitting the lots. It wasn't they were just developed before development standards were made. So I don't know how that relates to the issue, except the split was done before zoning came in. So they became non-conforming. So the zoning made them non-conforming versus that they were just non-conforming from someone else's doing, so I don't know how we have to deal with that, but you're allowed to split an AR one lot, 2 acres. It's just the frontage is not there because of what was created before zoning came in. So my hardship looks at that the zoning made the hardship by changing the law after the lots were made. I don't know how that sets, I mean, there's no Duncan standard for that I can see.
Our tax document shows that R1.
Yeah.
That is not considered acceptable when they shut the trustees down and dissolved the zoning commission and had to redo the.
That's right.
Hard tonight.
It's right in the middle.
It's just.
Right.
The court
So they wouldn't
decided
have the same
that
ability to
Township was not
repair
compliant with the
make that
law
flag.
on
No.
rules.
Right.
They've already got this flag line right away.
I remember that
And
day.
now there's gonna be another one here.
So these,
I didn't go to
these people
court.
don't have the
And the
same
judge decided,
ability
to fix it, and Harlem Township went into
to
another
do
township
repair.
and pulled their zoning resolution. They didn't start from scratch to develop a new road, free zoning resolution. They just brought in another township and used that, and the judge accepted that as post 1988 rezoning.
So the fact is that zoning resolution created non-conforming lots.
Right now, we were grandfathered as a conforming, non-legal, non-conforming AR1 lot, since we didn't have the 300-foot frontage.
I have a similar, my lot don't meet that. Understand.
I do.
And I guess I would respectfully disagree because it's a non-conforming lot, there is no
They're only
frontage.
supposed to have 300 feet.
The
Right.
fact that it's
Front footage on the road,
non-conforming, even though it doesn't
And none of these
meet
houses
the
do.
frontage standards,
These are all.
it's still lawfully
250 or
allowed to
something.
exist.
Yeah,
We're still unclear about what precisely they're seeking a variance from.
well, my contention is that the zoning change created the problem, not, it wasn't what they did, but the things they zoning did. And it didn't happen just to their lot, it
That would
happened
be
to 13
Kind of
lots
my question.
in the whole road. And so it's coming back now. It becomes a problem. And so to correct that problem,
Doesn't satisfy that, right?
Well,
we need to give a variance to
I'm not technically satisfied because they're all
Frontage.
less than 300.
requirement,
Should-
because it's still gonna be
Right.
a residential lot.
This here that
Use.
two flags separated by.
That's my contention now, I don't know how the rest of it's gonna feel.
Those are required frontage. 300?
Well, if it's AR1, but they don't conform, so they're not conforming lots. So
Okay,
I think we have to go to a different section of the book.
okay,
I'm
So-
not sure.
okay.
Anyone else have any ideas? questions?
Yeah, I had the same question you had. If it's AR1, it's 300 feet frontage and we're at like 250 for all these lots.
There's 13 lots.
And they sound like they're not conforming. We probably need to look at the non-conforming sections of the code to see how those are handled.
Like, get your book there, keep up non-conforming section.
24.01. 24.01.
2401. And
What's it say in there, the lots?
For those that I haven't met, this is Corey Go. I'm Corey Go. I'm from the Prosecuting Attorneys Association. So if you have any legal questions, I'm more than happy to answer those as well.
2405, non-conforming lots. It says. Okay, let me just read this section. So in the record, so section 24.05 non-conforming lots, it says the construction of the conforming structure and or the conduct of a permitted use shall be allowed on any lot of record at the time of the enactment of this resolution, which has an area and or a lot width less than the required for such structure or permitted use in the zoning district for which the lot is located. Variance of any development standard other than the minimum lot area and or minimum lot width shall be obtained only through the action of the Board of Zoning Appeals in accordance with provisions of Article 28. Such non-conforming lots must be separate ownership and not have continuous frontage with other land of the same ownership on the effective date of the applicable amendment to the zoning resolution. Otherwise, development shall be permitted only in accordance with development standards in the zoning district in which the ownership is located. Now, I kind of read that as what it's saying is a non-conforming lot, if it needs to be redone, has to come to the BZA in accordance with this Article 28, as long as it's under separate ownership. In other words, if they own adjoining lots and try to do this, it would apply because that they had continued. But since they only own one non-conforming lot, they have to come to the BZA to get permission to separate it. That's how I read that. I don't know how. If we all want to read that, also see how you understand that.
So if that was 300,
No, that's,
if it
if
was,
it was.
that would have been conforming.
Right.
But then still, so does it automatically make it conforming to be split?
Yeah, because.
What would happen when you make the flag lot? That maintain at least
175 feet.
has to be left on
Of the
The
300.
one property has to have 175
Then the
feet.
second
other
lot has to
60.
widen out to 175 feet, 50 feet in front of the building line.
Yeah, to the back, yeah, right.
So that's how it becomes a flag lot because the 40 or 60 foot, whatever right of way is, I think it's 60, it might be 40.
It's 60.
It's 60.
For the right of way, then it has to widen out to the 175 feet. 50 feet in front of the building line. So wherever they want to sit a house or building, then. But you can do that if you had a 300 foot lot. you wouldn't. That basically wouldn't, you still have to have. Some of the flag lot because you still have to have the 175 feet for the second lot.
Right.
Okay. Yes.
Okay.
What do you mean, seek your name?
Yes,
She's fine.
Okay.
I have a question. The gentleman, Jacobus gentleman said that you can get two conforming lots if you split his property.
Right.
Okay. You first have to go to an FR1 and then you can attempt to split it. The only way that his property can be split to get these two conforming lots is if you put that flag lot alongside of it on our property, along our side of the property.
One side or the other, right?
Now,
just-
we are in the middle. We would be in the middle. There would be a flag lot on our side, one side. We already have a flag lot on this side. And zoning, resolution says that if you look in, either the AR or the FR, it says that you need to have the required distance between two flag lots. And for an AR and an FR, if you were doing a required distance, 300 feet, we are between them and we are 242. So you're violating that part of your zoning resolution that has to treat that.
That's why we're here to give a variance to the resolution.
Well, that's another variance.
That's another variance.
That's
He's
not-
not asking for
They're
that
not asking
variance.
to relax that. Plus, flag lot has to be on our side. It can't be on the other side.
There's no way you can configure.
Because if you look at the drawing, the survey drawing on their application, there's a house there.
Right.
That's 20 some feet away. So the flag lot has to be on our side.
So this is a separate variance.
So you got multiple variances
So you
to
got
deal
multiple
with.
variances here.
Does the resolution specifically state 300 feet between properties?
It says the required. It says the required distance between it, and if you look, and what's the required distance of frontage for an AR or an FR of 5 acres, it's 300 feet.
Page 11 of that memorandum, you have 200 feet listed somewhere. So can we clarify that? I'm not sure if that's exactly what you're referencing. Last paragraph, page 11, second line.
Which says Green Cook Road is a rural corridor.
Yeah,
So what that's referring to are those platted parcels that are in the exhibit to that memorandum. Each of those is greater than 200 feet.
Yeah.
But not quite 300.
Can I have my mouth?
Yeah, sorry.
that was because that's what they were in 1872. And then in 1988, AR1 turned into 300 foot of frontage, right?
Which does that make that bring that non-conforming part in?
Right.
Yes, it's a substantial. Because I would do the rough math. Well, yeah. But I haven't read the 300 yet. Yes. Okay. I believe that's.
you're taking basically the requirements in the general development standards, the 300 feet, that doesn't apply to non-conforming lots. We're going back here to 2405, we're dealing with non-conforming lots, which says it has to come to BZA for a variance. You don't know that. So
It says the required, and today the required is 300
exactly,
feet.
I agree with that.
You can have 200, you can have 242 one time, you have 262 the next time. It doesn't say it's a variable distance, it says the required. It's well, the distance between the two flag homes.
And I agree that that's what the standard is today.
So I think the question where he's asked, I think the question he's asking
Not dealing
there,
with today's standard, we're dealing with the non-conforming lot standard, because the non-conforming lot, it goes back to the section 2405. And that says that the BZA has been granted variance because it's a non-conforming lot.
It would do additional harm to us because it squeezes us. We're not 300, we're 242, 50 feet. It's making a hardship on us and making it narrower so we would have, closer driveways to us, noise and traffic and everything.
That was put in to get rid of the bowling alley effect.
The way I read then this is again Corey from the prosecutor's office, the way I read 24.05 non-conforming lots suggests that the process is that a variance is sought through the Board of Zoning Appeals in accordance with the provisions of section 28, which is the section we're talking about. Section 28 then outlines the requirements in order to still meet the variance requirement, which are those factors that have been addressed a couple of times. So it's all that I think all that section does is direct that, yes, there are non-conforming lots, but if there is a non-conforming lot and there's a change that's requested, it has to go through the variance process through the BZA, and those factors are to be considered that are outlined in the zoning resolution. The idea that it's a non-conforming lot, it's a legal non-conforming lot, the only reason it becomes an issue is if any change is wanted on the lot, which is what's being requested here, is that there be a change so that it'll rezone eventually and a lot split can happen. So because of that change, that grandfathered in non-conforming lot sort of goes away, and you have to look at the property as if it's under the same zoning resolution that is active today. And that's where the issue becomes with the frontage issue, right? So when you kind of put all those sections together, that's why we're here today. That's why the applicant's here today seeking a variance, but you still have to go through those same variance procedures that are outlined in the zoning resolution, which is in consideration of those 7 factors that the court gave, whether there's a necessary hardship and those types of things. So you're still directed as a board to go through those factors to determine if those factors weigh in favor of granting the variance or not. Does that maybe help clarify a little bit?
Yeah.
And those are factors that are outlined just for purposes of this record. It's section 28.06 of the zoning resolution, named procedure on application for variance. And then under there, it's A, B, and C. C is what outlines the criteria, and specifically C in the net little section 4 that says area variance outlines 7 factors that are to be considered by the zoning by the BZA when determining whether a variance is appropriate, granting the variance is appropriate.
Yeah, what section you say that was?
That criteria is in section 28.06. It's labeled procedure on application for variance. It's page 2802 maybe, or I guess page 197, depending on how you're looking at it. And then area variance is kind of on the next page. It's under subsection C, which is listed as criteria. And those are some of the factors to consider that have been addressed by counsel from the adjacent property owner when he spoke today. So it's not contrary to public interest. It's justified due to special conditions, justified because the literal enforcement of the resolution would result in unnecessary hardship. And then for an area variance, which is what we're talking about here, there's the sort of practical difficulty factors, however you want to call those. And then there's 7 factors or 7 sentences, A through G there, that are all to be sort of considered and balanced and weighed by the board when determining whether the variance should be granted or not.
I would respectfully disagree. Your code says in granting such variance, the board shall determine that said variance meets the following criteria. It doesn't use the term way, so I
The court
think
says that though, right, counsel?
correct, but the resolution has different language in it.
And what would be, you're suggesting that the court hearing that outlines these factors and says it's a balancing test would not be precedent over the zoning resolution?
I would suggest that the zoning resolution requires that the board find that this meets all of the criteria as stated in your resolution.
It meets all.
If the resolution were silent, then it would be weighing, but because the resolution says it must meet the criteria, I guess that it meets all the criteria.
Which page? See, okay, okay.
Yeah, I got there.
I got
Well,
2019.
for purposes of right now, I guess my suggestion would be that it's a balancing test, which is what the court outlines. If counsel, if you have something from a court case that suggests if the zoning resolutions is more definite that that should be followed, I'd love to see that. But for purposes, I guess, for right now at least, those factors still need to be considered regardless. Would you agree?
They all have to be considered, yes, but again, our argument is that the resolution says that they all must be met. And under the language of the resolution, which you're required to follow, you find that all of these factors are met. At a minimum, perhaps the 7 factors should be weighed from Duncan, but 1, 2, and 3, you need to independently
Well,
find that those are met.
I'll say this, when I read number 4, area variance, and is this the 7 things you're talking about, these factors which are not exclusive, so that says that this is not exclusive, it doesn't mean it doesn't have to be all of them, or doesn't, or it can include all of them, I guess. So I don't know what does not exclusive mean to you versus what it means to me.
What the court has said is that this is a list of 7 factors. These are not all the factors that you're required to consider. You can consider other things as well. And again, in Duncan, the court does talk about weighing these factors. It doesn't say that they all have to be met. In some factors weighed favor.
I'm aware of the Duncan things.
But again,
Long
look at the
time.
language of your resolution, it does say that has to meet the following criteria.
In any event, I think that at this stage, those 4 criteria, 1, 2, 3, and then 4, and the subsets of 4, I think those are the factors that the BZA should be considering and whether a variance is appropriate. Now, whether you feel you have that information already presented in testimony or in the application that you can make that determination is a decision for the board. If the applicant wants to address those factors or wants additional time to address those factors, that's a decision they can make. But I think those 4 sections, so C criteria, and then 1, 2, 3, and 4, and those other factors, I think are the ones that are at issue for the board to be considering at today's hearing.
Can I table this for
Yep.
next month? And I have to review the memorandum that their attorneys submitted.
I would suggest that, in fact, I'd like to give you even 2 months because,
I'll probably make that motion a little bit here.
My suggestion would be if the applicant is seeking that it should come from the applicant since it's their application that has this strict timeline of when it needs to be followed. So if he wants to make that motion and has a specific time period he's looking for, I think it should come from the applicant.
reason why I'm saying
Respectfully.
because I know some of us won't be here January. And so, if you wanted to like to postpone to February, I'd entertain that too.
So I have a question on our zoning and I haven't located where AR1 or FR1 states the 200 feet between or 300.
It's in here.
It's, yeah, it does.
Uh,
It's,
Well,
it's,
It's here.
respectfully, that's part of the issue. We, at least as I sit here now, I still don't know whether they're seeking a variance under 7.06 or 8.06. 7.06 is for AR1, 8.06 is for F1. The application just isn't clear. Now, it's similar standards under both, but those are.
Well, my assumption would be it's currently an AR1 property.
Mhm.
Therefore, FR1 has nothing to do with it. They have to be, the fact that they want to, I mean, that splitting it is sort of part of their justification. It gives you an idea of intent, but is really irrelevant. And given, it's an AR1 property until that changes. So I think that's kind of the same thing you're saying is, I think that's where there's clarity. I know you're not required to show on the lot plan kind of how you would split the property to get to your 2.5, but on the flip side, it might be helpful for the education of the board to see something along those lines.
Counsel, do you, your client mentioned the 300 feet between flag lots. Do you know where that is in the zoning resolution? Because I don't
It's in
see that.
7.06 and 8.06, the last sentence.
in the development standards.
It's the last sentence. It doesn't say 300 feet specifically. It says the required.
Otherwise as required.
Required distance.
So it's talking about the property between the two flag lots needs to have the required distance pursuant to the zoning resolution, meaning it has to meet the zoning resolution as it stands today.
It says flag lots must be separated by a lot meeting the required footage at the front, or excuse me, at the right of way line on any road in the township.
So to be clear, the position isn't that there needs to be 300 feet between the two flag lots. It's that the property in between the two flag lots has to have 300 feet of frontage as required by the zoning resolution. Is that your position?
Well, it says separated by a lot meeting the required frontage.
Right, so the lot that needs to meet the required frontage would be your client's property because it's in between the two flag lots.
Yes, in this case, that's correct.
Okay. I'm sorry, that was my understanding. I wanted to make sure the board understood because I don't think that was entirely clear.
Yeah, that's, and both FR1 and AR1 read the same. Okay.
Again,
That was 706 and
did you say you
806?
wanted to ask for?
706 and 806?
More information? Or do you, I mean, that's up to you.
Do we know if we got enough time in an application to allow it to go to February or?
Oh, yeah,
Okay,
all we do is set to time certain,
okay.
day and time certain, that's all we have to do.
We can go till February. That works.
And just take a look at it.
Because I know our zoning director's on vacation till the rest of the end of the year, and you can't consult with him, and if it's, it's a bad time of year for meeting people. I know if you're going to do it to February, it'd be fine too.
Let's do February.
We would normally meet, I just look at the calendar, for February, third Monday in February. Well, actually, we got to talk about that too, that's a holiday. It's
Holiday.
President's Day.
President's Day.
Yeah.
I'm self-employed. I don't have any holidays.
If it's continued today to a date and time certain, that would, there would be no notice issues, requirements, additional notice would not need to go out for the second hearing.
We may we'll put it on the website
Sure.
and we may send something to the paper, just be sure.
You're not gonna send us a notice, a
Well,
written notice?
You're here tonight, you'll know the time's in place, so.
We're working on
We're
that.
working through that now before I interrupted.
Working on it, that's what we're trying to figure out. Because our next meeting
it's right here.
is also a holiday,
Right.
the next meeting is a holiday.
Right.
And then all the other holidays, we gotta, we gotta figure this out.
Solid.
Can we just push it a day into Tuesday?
I think this room may be used.
Can you see that, Ashley?
Yeah, I'll look real fast.
I
Can check that.
don't know. That's what I'm saying.
She's got the calendar.
And Wednesday would be trustees meeting normally.
Right.
Wednesday. Tuesday, I don't know who. Who has the
What are we looking at, the third Tuesday?
No, yeah, 18th.
Wednesday in February.
I apologize, we couldn't get there. It's a bit of a complicated.
No, the garden club's at Grange, but they will do it here.
I'll go to Grange, okay. Yeah, so we could do
And
it.
that would be the 18th.
18th. Good with that?
Now, would we just be having the hearing that day and also have the regular meeting the day before, or would we move the regular meeting to
We'll
Tuesday?
probably lose a regular meeting too. Because
Right.
Okay, so move regular meeting to Tuesday, also move the hearing to Tuesday. I just need to know what I'm posting.
Yeah, the adjourned
We'll
or
have-
recessed.
We'll get done the hearing, figure that out.
February 18th.
Yeah.
It's on my agenda, we'll look at the dates. So then I'll ask you if you want to make that February the 18th at 7:30.
Yes.
We have a request from the applicant to reset this hearing to February 18th at 7:30 PM here at the Harlem Township Firehouse.
Are we permitted to provide additional information
Sure.
to you for that?
Yeah, you can come, it's open meeting, you can do whatever you need to do.
The trustees kind of block it off. Hey, you can't go back in.
No, this is just a continuation.
Yeah, it's not,
So we're not, hasn't been, we're just recessing the discussion until then. But we'll reconvene the hearing that night.
If you want to include me, I'm their new zoning admin,
Okay.
essentially, for the time being. So if you want to include me on those emails also, I'll get everything printed out for them too, just in
Sure.
case one of the zoning guys aren't here or Corey doesn't get back to us right away. You know, he's bogged down with everybody else too, so it's just admin, ADMIN.
Yeah.
And that way I can make sure not only they get it to their email, but I'll get everything.
okay.
Is there a motion
Then
to,
we'll do, we need a motion to recess this hearing to April 18th.
To February 18th. Yeah, I make a motion to,
Before that,
go ahead.
would you provide a copy of the memorandum to the applicant?
Yes.
Thank you.
Recess this hearing to
Yeah, I make a motion to recess this hearing to meet again and on February 18th for further discussion,
7:30 PM.
7:30 PM.
I second the motion.
A motion and a second, have a roll call vote, please.
Keith Campbell,
Aye.
Jim Steele Smith, Steve Eisenbrown,
Aye.
Bill Gallagher,
Aye.
Kyle Ferris.
Aye.
Chris Peroni, Amy Richardson.
Aye.
This hearing is adjourned until February 18th at 7:30 PM. I thank you for all your help and input.
Thank you all.
You'd like, you can just have my copy and I can make.
Oh,
Like,
right, right.
that way you don't have to even worry about that.
Yeah, I want you. I'm right.
Start this part out.
I'm right, yeah.
Just.
Okay.
I don't know.
Pretty soon. Are we going into regular meeing or are we ending?
Switch to, good.
we're gonna reconvene.
Okay, perfect. Just wanted to make.
That's what I thought too, but I didn't realize he was on vacation.
Yeah.
So.
Sorry. just wanna get to it.
Yeah, good. Okay. Yeah, if you need anything, just reach out. That's my email, so. if you need-
Okay.
Between now and.
All right.
Are you the permanent replacement for Valerie or,
Yeah,
okay,
but who knows?
okay, but she's not doing it anymore. Is that correct? Okay.
Um,
That's-
I'm essentially.
I missed a
until-
meeting, or actually
Yes.
two.
I did
So,
too.
It's essentially until it gets too busy.
Okay.
Until either zoning gets too busy for me to keep up with the trustee, assistant administrative, or if trustee side gets too busy for zoning, then we'll pull somebody in.
This is as busy as it gets.
Yeah, this,
Yeah.
yeah.
Yeah. We're pretty laid back.
I
So,
like
yeah.
Love that.
Thanks for joining us this evening, Corey.
Absolutely.
Also, I'm Ashley, to put a name to the face.
You're the one who yells at me on the phone all the time?
I'm the one yelling over my,
Buddy,
yeah.
both of you taking turns yelling at me on the phone?
She's the only one.
Anything new? I'm used to that. At home, at work, it doesn't matter.
It's just one continuous cycle.
That's right.
I try to keep to myself in the back office, but then Mike will be like, let's just call Corey. I'm like, let's do it. Let's do
Yeah.
it. He knows your number by heart.
I think Mike calls me 3 or 4 times a week.
He knows your number by heart.
Yeah.
He does.
Keeps me busy.
All great information.
Anything else for me? You guys are still in session, I think, right now, right?
Right,
Yep.
yeah.
So anything else from me at this point? Any questions?
Yeah, I mean, that's, they're zoned AR1.
We're live
I don't-
here. We're recording.
Yeah.
too.
So if you have anything that shows any clarity on as we go that non-conforming portion. Right,
As you do
because
what? I'm sorry.
their frontage doesn't conform to the AR1, so that predates, so that pushes you in that non-conforming section a little bit. So if you have any insider clarity on some of that going forward, then
I think it's still those variance factors are still the ones that are the important ones to consider.
Yeah.
The non-conforming lot aspect of it really just complicates things.
we are live here.
Yeah, that's fine.
We're
That's why
recording,
I'm choosing what I'm saying a little more carefully, but it just complicates things. I'm being a little more PC, I guess, in case my boss is watching. But no, it just complicates things because once it's a legal non-conforming lot, you can continue using it in that same way, even though it doesn't comply with the zoning resolution. Until you want to make a change, and that's the only reason why this is an issue is because they want to make the change. But once they want to make that change, then that sort of grandfathered in non-conformity doesn't really matter anymore because now it has to comply with whatever the zoning resolution is today, right? And so because it has to follow what is today and you have that frontage issue, I think all the zoning resolution says is if it doesn't, you still have you can follow whatever that is, section 28, which is your section that says go through the variance process and seek a variance.
But it would be another variance as such.
Yeah, there's not an easy way to handle these because the easiest way to handle it would be just to go through the rezoning process, which is what the other property did. The problem with that is that it doesn't fit the rezoning process because of the frontage issue. So you have to almost get a variance first. You have to get a variance first in order to be able to eventually rezone.
That one
Which
looks
is why
messy.
It goes in front of you guys first. And then if there's a variance that's granted on any property and it fixes that issue, then they can maybe get a rezone or they can just do a lot split if it works out that way. But it adds an extra layer of confusion and complexity by needing to be in front of the BZA because of that non-conformity issue.
Gives you guys more to think about.
Well, I think this, the number 3 or C, depending on what you're reading, the essential character of the neighborhood, by, as she said, bowling alley.
Yeah.
And I'm sure that if they're gonna contest it, then that's what they're gonna come back to.
And in fairness, those factors really are difficult burdens to meet, I think, just in a general sense, because it's situations where there may be additional changes around you and now your property becomes, I would say landlocked, because it's obviously landlocked, but there's an issue where you can't do something on your property because of something else that
Right.
happened.
Right.
And that's usually when these situations come in and it gives that property owner a little more wiggle room, where this is kind of the opposite issue of that, which is why it gets complicated and confusing.
Okay,
So I don't know, I don't know the best way for a property owner to handle these situations other than maybe you're stuck, I don't know. In a general sense, of course.
And it might not be the only one, but there's 13 lots, I would just like it, and heck, all have the same issue.
Our office actually sees it a lot, not only area variance, but we see it a lot with like use variances. Where people have been living on the same property for 50, 100 years, whatever, and they ran a mechanic shop in their garage. And now they're in AR1 or FR1 or whatever it is, and they can't do that. Well, if they were grandfathered in, they can keep running that shop even though it doesn't comply. The problem is, and this has come up in the last couple of weeks, they want to go from a mechanic shop to something else. They say, well, I'm already able to do this, why can't I do this?
yeah,
And because of that little change, you lose that grandfathered in status, and now you gotta
Right.
comply with the zoning resolution today,
right.
and that's when it gets messy.
That's me, right by the end of my shop in the back.
Yeah, I think there's some, I forget which,
I don't plan on changing it. though.
one of my other clients, he wanted to do, he had a mechanic shop and he wanted to do more like boats, a marina type of thing. Be able to take boats in, be able to winterize them and hold them, and it was something totally different than what he was doing, so, yeah.
Okay.
Yes.
All right, appreciate
Hopefully
that.
that helped a little
Yeah.
bit,
For sure.
so,
I got it, paper in 3/4, I'm not conforming.
don't move anytime soon. Don't open up an ice rink or anything on your property.
I think you should open up a pumpkin shop.
There was my property,
Huh? Should sell pumpkins.
yeah. There's field next to me.
So
5 acres.
essentially, this whole area could go from
Developed.
13
feet over here,
to
just like this
26
tree line. The driveway
real
up there is
fast.
pole barn.
Yeah,
Yeah,
Oh,
I could do that. And I-
worry about the
Well,
law.
no, we can do that.
that's right. Changes everywhere. Well, if you need anything, you know where to find me. If you need my number, Mike Cannon has it memorized. Take care.
All right,
Thank
thanks. Watch the deer.
I'll do my best.
Fear the
Thank you, sir.
deer.
Of course.
Dark out.
Okay,
All right. I have a,
was that interesting?
I was just gonna say the same
I
thing.
have a sporting.
I didn't, I knew this was gonna bring an attorney. That's why I had my attorney.
No, it was good.
Well, I thought that was good because it made it a whole lot more informative, I think.
That guy, that attorney would just overwhelm us with information
Oh, yeah.
and that's why I had Corey sitting here and if we had a question, we could ask him. And
Are we?
Yeah, let's get back to
Yeah.
the meeting and then,
Yeah,
then,
maybe.
we need to finish up and.
Yep. I'm not sure what I'd like to make the motion, we restart the regular monthly meeting.
I'm second.
Yes.
Uh,
Yeah.
Motion second to reconvene regular meeting, all in favor, say aye.
All right.
Aye.
Please call the roll, call the roll, please.
Campbell,
Here.
Jim Steele Smith, Steve Eisenbrow.
Here,
Bill Gallagher.
Here,
Kyle Ferris.
Here.
Chris Baroni, Amy Richardson.
Here,
Okay, back to my agenda. We were, what we did, what we didn't do, that's all. Oh,
Looks like we're up to new business, right?
Yep.
We did the minutes.
we have no new business.
yeah, we did.
We do. We had no zoning director's report, he's not here, we no applications, whatever. We need to talk meeting dates, basically. Yeah, we kind of did, we made one.
The Jacob's hearing is February 18th at 7:30. You guys mentioned wanting to move the regular meeting to that same day.
Yeah.
Mhm.
February 18th, was it?
Yes.
Okay,
And we set the organization meeting for 7 o'clock on the 20th.
well, that's a holiday too, so it's up to you guys, it's,
Oh, MLK.
Inauguration, okay.
And the inauguration too.
I don't know if you want to continue this on Monday that day or not, that's up to you guys, so that's why I want to ask the question.
I think we ought to keep our date.
Yeah, I'm okay with the,
Me too.
I won't be here. So that's fine,
he's on
Oh.
vacation.
I'm on vacation, so. That's what I'm saying, you know,
We might need you.
but I won't be back until February eighth.
Oh,
Nice.
when do you leave?
The 17th, 18th, somewhere in there. Of January.
Well, because the trustees, and I don't know why, is on the 15th. Oh, that would be their third. Yeah, okay. Third Wednesday. Well, I guess, do you want to pull it forward?
Do we have, how much lead time do we have to change the meeting?
All we should have to do is advertise it 10 days ahead of time.
10 days, okay. So is there that we can pull it forward that you can make?
Well, let me look at it. I gotta bring a calendar.
It'll be the 13th.
I can't do the Monday, the 13th, but I could do the 14th, the Tuesday.
14th.
You have to remember, we can't do any other Mondays because that's commission.
Can we do Tuesday, the
We can't do-
14th?
We can't do the Monday, the second Monday.
Right,
it's zoning
because of
commission.
zoning.
Right.
So,
So
Second
the,
Monday is zoning, second Tuesday is communications.
oh, that's the 14th.
We can share this committee. I'm on that committee.
Second Wednesday, we have the trustee reorg.
They're doing the
And the
re-
15th,
Oh, they
we have the
did-
regular trustee.
On the 15th, they were your job time in the evening or in the morning.
So on the 8th, we're doing the reorganization and we have the Jackson hearing,
On the 8th.
on the 8th. And then the 15th is the regular meeting for the trustees.
That's the third Wednesday.
Uh, third Wednesday,
It's
well,
Thursday.
that would be the third Wednesday.
that
is the
is,
15th.
Yeah.
The fourth Wednesday is 22nd.
but he's gone. Keith's
Okay, you're
I'm
gone.
still,
gone.
I'm still going, I'm going from the 18th, well, 17th. 17th through the 4th or 5th of February.
We might be able to get the communications group to swap us for between the 14th and the 21st. So we could meet while Keith is here.
You don't have to have me to do the organization. That's, that's.
What about the 8th?
I could do that.
No.
No. What about the 9th?
Trustee reorg.
I can do the 9th.
It's at
1 o'clock.
1 and then a hearing at 2:30.
So by 7:30, they should be done.
Hopefully. Nope, but then Parks has it at 5:30.
We can meet in your office.
Try again.
I will say, if you do on the 8th, I won't be here. I will have already been in like 3 meetings that month and they're all day in meetings. So I would do your minutes later, but I don't know that I could make that
I know.
extension of the meeting. That would be my only
Um,
thing. Obviously, I don't need to be there. I can always do it.
So the 9th?
Thursday the 9th. I could do that.
Thursday. The 9th. At 9 o'clock.
This room's clear. Brain pulse.
Okay.
Hmm.
Fine.
Excuse me?
Well,
Don't make me do a meeting before I go on vacation. Like you guys are,
So now we're on January 9th at 7,
That's-
right?
7 or 7:30, whatever you want.
And this is for the reorganization.
Yeah, well, for
Regular-
both.
Oh, yeah,
7 for the organization and 7:30 for the meeting, regular meeting.
So we're just moving.
We're moving
So
off
we're
of it.
moving all of the January meeting and all of the February meetings. Cool. I just need to know what to post. So reorg at 7
Yes.
and regular meeting at 7:30.
I wrote reorg too. Is it organizational though?
Organization.
Okay.
Yeah.
I had to cross out reorg.
And what is that?
I might have said that too. That might-
What's the date?
When we organizational meeting is when
January?
January.
we elect
the
new chairperson, vice
Ninth.
chairperson, and we
January
schedule our
9th.
board meetings for the year.
Oh.
And then
7 and then
we can
7:30.
also
And then February's the 18th.
So January 9th at 7 o'clock is the
Right.
organization,
Mhm.
7:30 is a regular January meeting. Then February 18th at 7:30 is the regular meeting
Plus a
plus the hearing.
The hearing will start at 7:30 and the
7:30.
regular meeting to follow.
Right.
That's what you told them, so that's what we'll.
Yeah, because we're resuming, so, yeah.
So I'm not gonna put an exact time for the actual regular meeting, it'll just say to follow.
That's a smart move.
That way, you guys stay.
So during the reorganizational meeting, we already have the January and February holidays figured out, so that kind of took care of those two. We can, don't do a regular third Monday at 7:30,
Right.
it's fine.
So to confirm with you guys, just to make sure, we are gonna cancel the January 20th BZA meeting.
Right.
Do we need a motion for that?
We'll get that one here in a minute.
And then we're canceling the February, what is that?
Would have been the 17th.
The 17th, okay.
We're just moving it to the 18th. And there's a clause in there, I think in some of that, it says if, it's the third Monday, except maybe a holiday, then maybe a different day. I think there's something-
Yeah, there's something that says like if it's on holiday, it can be moved. We'll still advertise it just in case, especially with the hearing
Right.
and the reorganization, just because they're both considered special meetings. I just wanna make sure you guys are covered on all bases. It's not gonna hurt us to overpost. It will hurt to underpost, so I'll just make sure it's everywhere for you.
And March will be 17th.
St. Patrick's Day.
St.
Now, is
Patrick's
that
Day.
a holiday?
It's a national holiday, it's a holiday.
I will not be here.
Can we have green beer?
You're bringing the green beer.
I will not be attending that day or the next.
Wow.
So-
Plan.
Our family is very Irish, so.
We may have to put that down to the 24th. But it happens, it just, ours always follow the holidays.
They do,
for a
being the
lot-
Monday.
May, June. July. At least the 4th of July is not on the third Monday. Yeah, okay.
Figure that one out in January.
We got that all figured out?
Mhm.
We got
Yeah.
that figured out?
I think so, I'm ready for some motions. when
Need a
you are.
motion to make that official.
I make a motion that we have the January meeting, move it to the 9th. At 7 o'clock for the organizational meeting and 7:30 for the regular January monthly meeting. And for February, we move the meeting to the 18th, which will be the hearing at 7:30 and the regular monthly meeting to follow.
A second.
Motion and a second. All in favor, say aye.
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 Opposed, same sign. It's done, it's history. We're on.
That was easy.
If nothing else, then a motion to adjourn. Is there anything else to bring up?
I'll make a motion to adjourn.
Second.
I'll second it.
All in favor, say aye.
Aye.
Opposed, same sign.
You want our folders back?
Yes, please.
Oh.
Empty folder, because we keep the paperwork, right?